I will share competency issues are very, very significant right now in our profession in terms of just malpractice claims, disciplinary complaints, et cetera. Dementia is a very growing, significant problem. I want to start talking about transitions. And that's look at this navigating or mastering the transition from, leadership to legacy. That's start to go there. You need to properly destroy this stuff with a digital erase. Or physically have drives shredded. That's true for phones, backup tapes. We need to think about all the places this data is. This is not optional, folks.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Mark Basingthwaite. Mark Basingthwaite, since 1998, has been a risk manager with ALPS, the nation's largest direct writer of lawyers' malpractice insurance. In his tenure with the company, Mr. Basingthwaite has conducted over 1,200 law firm risk management assessment visits and presented over 650 continuing legal education courses throughout the United States. He has also written extensively on risk management, ethics, and technology, and is a member of the State Bar of Montana, as well as the American Bar Association, where he currently sits on the ABA Center for Professional Responsibilities Conference Planning Committee. The webinar presentation that you're about to watch will be approximately an hour and a half, and once that's complete, Mark will be taking audience questions, time permitting. But if you have any questions that come up during the presentation, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Mark to discuss Succession Planning Unlocked, Mastering the Transition from Leadership to Legacy.
Well, thank you and welcome. Before we get started, I'd like to just sort of set this up, I guess, a little bit. In my role, I've been a risk manager here at ALPS for a little over 27 years. And sometime I'm going to write a book about all the experiences. But I've had a number of situations come up, questions, problems, et cetera, dealing with succession planning. And one of the things, when we sit and talk about these things in terms of having a plan, et cetera, one of the things that I've heard over the years is, Mark, my plan is I'm going to die at my desk. That's just the way it is. Okay. That's not really a plan from my perspective, but I have seen and heard that more than a few times. Let me tell you how that plays. Because I'm one of these that at times gets the call. And the call is, my husband, lawyer, typically it's a male. Every once in a while it'll be a woman, but has passed, literally sitting at their desk. They never retired, never did anything. And there's no succession plan. And you can hear it in their voice. I am so angry with this my husband. They're also trying to deal with the grief and processing everything. And they're just overwhelmed. He left no instructions. I have no idea what to do. Can you send somebody out here? The bar won't. And as much as I'd love to, insurance companies don't have the financial wherewithal to start sending lawyers out or paying lawyers to wrap this stuff up. Nobody's paid any premium for it. It's just not a service carriers can provide. At times I will try to do the best I can to explain the kinds of things that should be done, preserving records and, do we have active matters, and try and, find somebody. What ends up happening, you may have a lawyer to sort of step in and try to deal with some of the active things, but that's all. They're just not interested. And sometimes they simply don't have the time. Think more in remote areas as an example. And they're traveling just to do the basics. And remember, the ethical rules don't apply to a non-lawyer spouse. And so what ends up happening is these folks, because they're trying to move on process through their grief, work through the anger, etc. And they just have everything picked up. They just send it all to the garbage dump, all these records, and they, fire sale the furniture, and they just get rid of everything. And then every once in a while, a claim will come up, and there's no record. And then at that point, sort of reach out. Somebody said we should call. I think Bob or Bill or who had some malpractice insurance. Let's give them a call. And this might be 6 months, 12 months, 18 months down the road, and they'll call in and want to report a claim, and there's no tail. There's no insurance in place because she never knew. Nobody ever told her to contact the company and say, well, this lawyer has passed away and we need to get a tail. And there's a clock ticking here. So now the estate that you thought you'd left isn't necessarily what you thought it would be, depending on how significant a loss might be in these situations. Please hear me clearly, folks. I am not making things up. I am telling stories of the experiences I've had with lawyers over the years. Don't go there. Don't just plant it at your desk. And I've had lawyers actually tell me, once I'm dead, it's not my problem. I'm going to be dead. What do I get? People are impacted by this. They are. I can also share that the kind of planning we're going to be talking about today, a lot of this will focus on solos, but the issues are not limited to solo attorneys by any stretch of the imagination. So I can share, and we'll talk a little bit about some of the things to do and some stories about firms. Sometimes you find in firms, as we start to get to 5, 15, 20 lawyers, and even higher, there may be a plan informally in place. We sort of talk a little bit of how, well, we need to transition clients and we'll figure that out. But you know what? One of the problems is at times getting the lawyer to follow through with the plan because it's so informed. There's never any discussions. This is just sort of, well, this is how we think we're going to handle it. That's not a plan either. So I just want to set some things up. Okay. We've already talked about who I am. We'll just move through this here in just a moment. Where I'd like to start now that we sort of have this set up is I want to share some risk management advice. And it kind of, again, sets the frame a little bit in my mind. And I just would like you to think about some things. So I have a story to share. Again, we're all getting older. It's just normal. It's natural, and someday this time is going to come. Well, what time are we talking about? I had an interesting conversation with one of our insureds a number of years ago, but I fondly remember it to this day. And we were talking about risk in general and all sorts of things, and it was a great conversation. Good guy. And all of a sudden, he kind of stopped and did this jump shift on me, and he said, Mark, I want you to know that I have come to realize, I'm getting older and I'm cognizant of what is happening to me, physically, mentally, etc. And I've taken some steps to make sure that I continue to practice law competently. And what really struck me was he shared that he had instructed others, partners, some key staff at his firm, to let him know if they were ever to see him start to mentally slip, to please talk to him because someday the day will eventually come when he is not going to be competent. And we could launch into a whole nother discussion. I won't today, but I will share competency issues are very, very significant right now in our profession in terms of just malpractice claims, disciplinary complaints, et cetera. Dementia is a very growing, significant problem. So I share this story because I found his comments very reassuring. In my mind, this is someone that I would describe as growing old gracefully, just not fighting the process, not living in denial. And I've seen a lot of other lawyers live in denial and fight the process tooth and nail, and he just recognized that with age, certain risks can come into play, and he's going to do something about that reality. So a couple of just very brief sort of risk thoughts tying into this. Um, you know, I think one of the most obvious sort of risks that can come with aging is an unexpected death, an unexpected serious illness, think cancer diagnosis. That's not good. Think even just accidents or a medical crisis of some sort that can result in long-term or even permanent disability. And all of these things can just, happen suddenly and, life changes. So it underscores the necessity of backup attorneys, naming a successor, and we'll dig into that a little bit more shortly. But there's other things to think about. Lawyers, well, I tell you, I'll be very honest. I recently turned 65, and I've been thinking about lots of things of late. And I'll share some personal stories as we go through this. But my vision isn't what it used to be. I remember years ago started realizing I couldn't read the wine list. My wife and I enjoy some evenings out and and some nice restaurants, and I needed the cheaters. And my hearing, I listened to a few many loud rock concerts in my teen years, isn't quite as sharp. So we have to understand there's some changes coming into play, and it's normal and it's natural. Please don't fight it. you know have your eyes checked, because I don't want to see you miscalendar something or misread the calendar, just as an example. I don't have your hearing checked. I don't want you to be so embarrassed to say for the fifth time, Your Honor, please can you repeat that? I didn't hear you. And lawyers, we can be, well, as we start to get afraid or embarrassed to speak up and share these kinds of things, mistakes can and will occur. We see them here at Alps. We really do. So transition, deal with this. If you need larger screens on your computer, great. If you need to get a hearing aid, fine. Go out and do it. If you're starting to be a little concerned about forgetfulness, start to use checklists. Maybe talk with partners about, do you transition out of aggressive, active litigation and start to move into a mentoring role? I mean, there's all kinds of things that can be done, so as we age and all this, I'm just trying to say, don't be in denial. Don't be frightened by it. It's a transition. Embrace what is happening so that you can extend or have the at least opportunity, short of something unexpected happening, to extend sort of your. We talk about physical and mental health span as opposed to lifespan, but I like this idea of health span too, in terms of healthy practice of law, that we can stay healthy and fully invested and competent and enjoying it for many years to come. Just don't push this stuff off to the side. My final comment about this, the day will come when, as we age, particularly with a lot of our long-term clients, we need to acknowledge and understand they are aging too and dealing with very similar issues. So, um, you know, uh, don't allow. I sort of see two risks here that are immediately obvious or come to my mind. I don't want to allow, as we get older and deal with the things that are normal as we all get older, I don't want to allow a long-term relationship to sort of push us. A client will say, Mark, can you do this? But I don't do this work anymore. I haven't done it for years, or it's a new practice area. I don't want you to feel compelled and forced to say yes because of what might happen if I say no. There are very good and easy ways to say, hey, Bob, I'd sure love to, but this is just not something I'm comfortable with anymore. But, my partner here or associate here, I can make a referral. I want to make sure your needs get met in the best, most competent way possible. How is that, a negative? The other piece that I would say is competency, hearing, vision, etc. All they're going through the same thing too. So, from a risk perspective, maybe at times you need to double check and make sure that your clients are not only hearing, but truly understanding the decision making process, the advice being given. It's because mistakes can and will be made. They'll say, I didn't realize, I didn't understand that this was a ramification of what you had me do, because it's always going to be the lawyer's fault. So food for thought. So that's sort of some background kinds of things. That's kind of move and really start to dig down a bit into all of this. Let's look at Rule 1.3, and I think most of us are well aware of what 1.3 says. It's basically, a lawyer shall act with reasonable diligence and promptness in representing a client. Okay, yeah, that's pretty standard across the jurisdiction, across the states. Earlier in this century, a comment was added to this rule, and it's comment 5 in the model rules. But I want to share it with you all. To prevent neglect of client matters in the event of a sole practitioner's death or disability, the duty of diligence may require that each sole practitioner prepare a plan in conformity, with applicable rules that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine if there's a need for immediate protective action. Now, I can share in some states, this may require, has been changed. It requires, as a risk guy, I don't see how it's optional. Again, I'll be sharing another story here in just a moment, but think about the stories with the spouses, the unsuspecting spouses. The clients are harmed, your legacy may be harmed, the financial security of family surviving, whether it's children and spouse, they may be harmed. So I really see this as not optional. Okay, so let me tell you a little story here. Another true situation. A number of years ago, we had a solo attorney that was one of our insureds and practicing in the Las Vegas area. And that's important to this story because at the time, Las Vegas was experiencing a very significant growth period, and finding competent employees in a lot of different industries was quite the challenge. But a solo attorney just trying to find anybody to come in and help her out. She had just lost an employee that I don't know, moved away, or that doesn't really matter. But she couldn't find anybody that had any experience or any exposure to the sort of the legal space. But she did hire somebody and was in the process of teaching basic, just basic receptionist stuff. And hopefully over time, this individual learn more and more and become a valuable member of the team here. It's just the two of them, but unfortunately, and who could see this one coming, it wasn't long after this individual was hired, the attorney was involved in a very serious automobile accident and ended up in a coma for about 35 days. Of course, the phone is ringing. This individual had no idea what to do and, was taking notes and phone numbers and trying her best to explain, well, Mrs. Smith has been in a car accident. She's in a coma. As soon as she's back and I'll make sure she calls, and she's just trying to do the best she can. To make sort of a little bit longer story short, the end result is by the time the attorney was able to start to even step back into practice and just begin to pick up some pieces and figure out what all had happened, 5 statutes were blown, and we had these claims to deal with. So that's just another example. I have to just underscore, if you don't have a backup, and I like to combine these. I think they're good reasons too, but a backup slash successor attorney named, now's the time. Please do so. Here's one little side note. I couldn't believe this when I heard it, but I am absolutely certain this happens. This this is just a couple of months ago. A lawyer passed away, and there was the bar was aware that a successor had been named and contacted the successor and saying, you're up. This is unexpected. That thing was, I don't know what you're talking about. I never agreed. I don't even know who this lawyer is. I never agreed to any of this. I'm not doing it. So don't play this game, pick somebody and shh, don't tell, go out and find somebody. And let me share a couple of thoughts about, I also want to speak to those of you that might be asked. Sometimes it's hard to ask because we're afraid this is such a heavy lift. And lawyers are afraid that are being asked to say, sure, because they believe and fear it's a heavy lift. I do not have time to take on a second practice. I'm already, dealing with a full practice. First off, I just want to say, it's not taking over a practice. That's not what a successor does. The responsibilities of a successor are to administer the winding up of the practice. That's a different piece. Okay. It's not picking up everything and running. It's trying to, sending out the letters, and we'll talk about some things here that need to be done. But the other thing that I will share is sometimes lawyers will want to say no because is what if I get sued? Do I have coverage for that? Look, first off, again, you're administering the winding up. You are not taking on any new clients. I mean, you could choose to if you wanted to take a couple and help out. Okay, God bless. But if, as a result of handling these responsibilities, and for some crazy reason, some odd, unexpected claim, and I have yet to see that happen, comes out of doing this service, handling this responsibility, I, for the life of me, can't imagine, and I can't speak for every carrier in the country, folks, obviously, but you would be foolhardy to try to deny a claim like that because the lawyer is doing everything he or she can to help prevent claims from arising. Why in the world would you go after that individual? Of course you're going to defend, because I can't see any losses coming out of this, but I guess never say never, but as a risk guy, I don't think that's legit. I'm not going to lose any sleep over that. If somebody were asking me, am I going to get sued? I'm just not going to worry about that one. The final comment when it comes to successors, particularly in areas where there might be a couple of lawyers in town that could all use the benefit from having a successor. There's no rule or anything that says this has to be limited to one person. I've seen situations where 4 or 5 lawyers will get together and agree to be the successor, and sometimes also backup attorneys if were necessary, so people can take a vacation out again. But and that can work quite well. I was aware of a situation a number of years ago in Montana where a lawyer in his early 50s suddenly, what happened in a climbing accident? Just fall. So suddenly passed away in a very catastrophic way. And four other lawyers stepped in and shared the load, shared the responsibilities, and it went quite smoothly. They were very efficient, and the spouse and family were just very relieved that this was taken care of so effectively and efficiently, and they just treated the family very well, very concerned, and don't worry, we got it. So I just want you, I'm trying to help all of you get past some of these excuses that come up on either side, the ask and the answer. So let's look at that. So, what, again, I want to focus on what does the winding down process look like if you are brought in as a successor. Um, it's doing file review. It's sending out client notifications. It's taking any necessary protective action, and transitioning files. I mean, that's really the gist of it. Okay. Um, in preparation for this, we also need to kind of think about what do we need to do so that I can do everything I can to make sure that if I suddenly pass or am no longer available for whatever reason, um, I want to assure the success of the successor attorney. So, what kinds of things should you be thinking about to do? And this is important. One of the first things that I would do, I see this, and I'm not kidding you, but I see this as something of a beneficial market kind of decision. I think it can help with client acquisition and retention. So if look at it this way, put a little statement in your pre-agreement, okay? And I'll read and all of this, when I read this stuff, this is in the written materials too, so you don't need to take notes or anything on this. But um, if I'm walking in and I get handed a fee agreement after discussion as I'm still thinking through, do I want to hire this person or not? And I see this little provision in the agreement. While I strive to deliver excellent legal services to all my clients, I also have an ethical obligation to protect your interests during any extended absences, such as a vacation, or in the event of my unexpected death or disability. To accomplish this, I have named, of course, you put in your successor attorney, as my backup attorney who will be available during any extended absences or will step in to assist in the winding up of my practice should that ever prove necessary. I will personally provide you with advance notice of any planned absences, and my office staff or backup attorney will contact you with information on how to proceed should any unexpected event ever occur. If I read something like that, I'm I'm going to respond with, I'm impressed. We have yet to start an attorney-client relationship formally. And this attorney that I'm now really gonna hire has already taken steps to protect my interests. This person gets it. I want to hire somebody that is doing everything he or she can do to to protect my interests and to move forward. Another way to say this, I feel like, boy, am I going to be in competent hands here. This is somebody thinking ahead. I like that. I'm impressed by that. Some other things I would encourage you, and this is useful for a backup attorney or a successor. Um, and you could broaden it even if staff come on board and things, but just have an instruction manual. Leave some instructions. What if you were to suddenly die tomorrow? Knock on wood, of course, this doesn't happen, but um, what would and how do I say? So if you were to pass, but you also know, okay, I'm now going to come back and have to take over this practice. What do you know that everybody else doesn't know but needs to know? You see where I'm trying to go with that? So I wanted to have a procedure manual. What is the calendaring system? How does that work? What's the true master calendar? Because sometimes there are systems that don't have everything. Where's the conflict list? How does that process work? What's the active file list? Where do I find that? How do the open and close file systems work? Is there a numbering system? Where are they located? The accounting system. Is this clicked in? What do I need to know? And any other key systems. Um, you know, what do we it's just enabling help them help your clients. Okay. It's also critically important to keep all these systems and your files current and updated. Okay. You know, so I think at times lawyers don't always prioritize keeping systems and files updated as much as they do. And I've always looked at it as a time and trust thing. They don't have the time and they trust their memory. Problem is, you're not here anymore. So the intellectual capital, if you will, and all the knowledge you have about these active matters isn't available. Can mistakes happen as a result of that? Absolutely, they can. So I encourage you, keep your systems in terms of your calendar current, keep the conflict database current, and really focus on keeping your files in terms of the documentation. And of course, filing things. I've gone into firms where mail is backed up. I'm not kidding you, 3 or 4 months because nobody's filing it. Oh, that's not good. But keep them current. And when we talk about file documentation, think about it in this way. A file that is properly and thoroughly documented has a complete record of the advice being given in the decision-making process. Okay. So we've got to capture relevant email, substantive text. All this has to be available for the next person that's going to step in. So how does he or she find that if it's not in the file? You see how missteps can start to occur. So keep these things well documented and updated. The final thing that I would add to this, and I can share, there have been situations where the cost incurred as a result of the attorney not doing this can be very, very significant. I'm aware of one situation where the cost was over $100,000. And it was an interesting situation. A state bar actually went in and ended up having to spend this money. And this is not something bars normally do. There's a long involved story as to why they had to do this or felt they had to. But they sued the estate to try to recover that. Because again, they just don't have this kind of money sitting around. Um, but it's passwords. It's access to these systems. So how does the attorney get into your online banking? Or how does the attorney get into Clio? Sometimes it's just, how do I get into the laptop to even access any of this stuff? I mean, if you're a true solo and, nobody else knows, that can be a real problem. So, perhaps we have a letter, a designated letter, excuse me, kept in a safety deposit box, or I mean, there are different ways to do this, and you write and share the key information. So, and then you tell your staff person or your spouse, just a key person in your life. If I ever pass, make sure here's a letter or here's where it is. Make sure this gets to Bob Jones. That's whoever the backup successor is. And that will help him or her get started. It's just, don't make it hard. Now, of course, thinking back to my story with the Las Vegas lawyer, um, if she had had a successor attorney named, you would want to tell even the new receptionist, bless her heart, that's trying to, you know, do the best she can. If something happens to me, here's who to call. And, because the best laid plans don't go anywhere if nobody knows that they're made and how to start them, how to implement them. So, okay, I'm just looking. Oh, well, the one other thing I would share, or I just have some dry ice, very dry. I'm traveling on business and I'm out here in Montana, just a lot of dry air. Um, there are some good resources available um, to help with planning and naming, designating attorneys and agreements and whatnot. The original product that came out a number of years ago was written and produced by the Oregon State Bar, and it's actually available for free. And it's called Planning Ahead, and this is in your materials too, folks. Planning Ahead, a guide to protecting your client's interest in the event of your disability or death. So I just want to share that there are tools out there. A number of states around the country actually have adapted the Oregon materials and to some degree, made them Virginia friendly or South Carolina friendly or something like that. So you might also check with your state bar to see if these forms are available and sort of tailored more for your jurisdiction. But there are some really good resources out there. The problem is just a lot of people don't know. So, okay. So now that we have sort of this planning process, the successor named, et cetera. We've taken care of our ethical responsibilities up front. I want to start talking about transitions. And that's look at this navigating or mastering the transition from, leadership to legacy. That's start to go there. Normally, the initial planning stage starts with figuring out when. And I will share, unless there's this serious accident, disability or a very serious cancer diagnosis things, normally you're not going to wake up one morning and just today's the day and I'm going to retire and close it. It doesn't work that way. Um, I've shared I'm 65. My wife and I have been talking about when and doing some of the planning, and I'll be sharing things that I've been thinking about for now, at least 4 to 5 years. I don't have when completely figured out. I have talked to lots and lots of people as I educate myself, and also I take what I learn and I put it into various programs or things that I write. Um, the number one thing I hear is, which is kind of interesting, you will know. At some point, you'll just realize you're kind of ready. It doesn't mean the next morning. There's a lot of things to transition to get there, but so, okay, maybe that's the way it'll play. Maybe it'll not. I still haven't totally solved when, but and I'm going to give you some things to think about. And as my wife and I have worked through some of these, I kind of kid around now. So I've been doing a lot of traveling for many years here with Alps, and I started to say, I don't know when it is, so I'm going to create these deadlines or these bright lines. I don't know how to hold to them. But when I hit 2 million miles on Delta Airlines, I think I'm going to be ready. It's just that these odd things is what I start to think about. But I do want to share that successful retirements don't really magically happen, and don't leave it to chance. I really encourage you to think about it. And I will acknowledge change can be hard. It's one of the things that I'm working through myself. Um, I also hear at times, now's not the time to think about this. And I don't care how old you are or how young you are. My response is, if you're not starting to think about it now, well, when are you? And it could be as simple as this, so the younger you are, if you want to have some flexibility on when, are you taking steps to even financially prepare? I have worked, I am not kidding you folks, with a lot of lawyers. And I say a lot, dozens and dozens. I'm not hundreds and hundreds, but who absolutely will never be able to retire because they didn't do the financial planning piece. They just left it go and assumed it would work itself out, and it didn't. So there are lots of things. I would encourage you to think about some things, some realities, and some desires. As you're getting, more toward my age, perhaps, is these are some example kinds of things to think about. How is your physical health or the health of a significant other? How long can you manage the pace of your current circumstances? Is there anyone you may be called upon to care for in the coming years, perhaps an elderly parent or grandchild with special needs? When will you have this financial wherewithal to retire? That's something, I'll be very open and honest. How much is enough? We're blessed. We're going to be able to retire. I'm not sitting on millions and millions and millions of dollars, but I think we're going to be able to retire and be okay and maintain the lifestyle. But you watch these markets and the world turmoil, and you say, you know, so, but you have to take steps to get to the point of saying, well, I think, maybe in a few years, I think I probably can retire. If you don't have the financial wherewithal to retire, if or the date seems too far off, are there steps you can take now to shorten this overall time frame? Again, my wife and I, about 15 years ago, did some significant financial restructuring, and that's what enabled us to be where we are today. And that was a lot of hard work, but worth all the energy and effort it took. You might ask, do you still like what you're doing professionally? Or are you starting to find that law is a distraction from what you'd really like to be doing? Do you find a call of family time, volunteer work, extended travel, personal hobbies, or even just trying your hand at making a little money doing that one thing you always wanted to do? Is that a strong calling? Do you even have the energy to stay with it? Or does work start to feel like a burden, more and more? I still get up in the morning and go, I like what I do. And I'm very happy to still have the privilege to be in this seat in terms of risk manager here at the house. Uh, Another reality is, are you as sharp as you used to be? Or if colleagues, family members, or trusted friends began to suggest you slow down or stop practicing out of concern for your well-being? Again, age, as we talked about earlier on, does a way of catching up. And sometimes what's best for our clients is a decision to stop before something serious occurs. So these are the kinds of things. What are the realities? What are desires? I do at times. I don't want to be in this chair the rest of my life. And it has nothing to do with whether I enjoy this, feel fulfilled. I absolutely do. But I also, you know, there are times, much of my life, professional life, is figuring out what can go wrong. Cybercrime, malpractice, ethical missteps. And I'm just one of these persons that has a natural bent to see all the risks. I'm not a guy that's going to jump out of an airplane strapped to some guy's you know, front, I guess in tandem. I think the novice is in front, or a bungee jumping off a bridge. Not me. Not me. No, I do some exciting things, but I'm not this huge risk taker. But I also have this bent of seeing all the things that can go wrong. And my I also am good at figuring out how to prevent these problems, which is again why I sit here. But at some point in my life, and I'm not kidding you, I would love to work at Walt Disney World. And we live now, recently moved down into right outside of Orlando and in a 55 plus community. And we just absolutely love it. We've always been Northerners, but we've been Disney people for many, many years too. And I'd love to just be on Main Street selling balloons. And I see some kid melting down, and I'm just going to walk up, and I don't care if I have to pay for this. Here's a balloon. Have a nice day. Because I want to have a different experience, to celebrate the joy and the fun in people's lives, as opposed to always being, I get calls. Can you come talk about this, that, or, oh, we want that program where you scare the bejesus out of them. That's always a cybersecurity program. And, it's fun. I enjoy what I do, but I want something different. I love to cook. I really do. I'm good at it. My daughter and her husband are professional chefs, both of them. We kid around at some point, if they ever open up, and they have several different things they're looking at and do already. But if they ever open up this small restaurant that they always dream about, and it's anywhere near me, we've always kidded, I'm going to come in one night a week and cook. And I'll do about maybe 20 plates or something like that. And it'll be advertised on the menu, the old man special. And when it runs out, it runs out. And I'll do my crazy fun things and it'll be something different every time. But I think that would be awesome. So I do see things beyond. So, okay, let's see. I'm getting off. So you need to start to think about these, when, and I strongly encourage you folks, do not make this, unless you're, again, truly single, um, something that you do just yourself. My wife and I have been talking about this for a number of years. And I visit even with friends. Some are retired and some aren't. And what were you thinking about when? Learn, okay? So that's sort of the initial stage. Now let's talk about how do you view what comes next? I have seen some very, very successful um, retirements and some huge failures. And in part, it's because of this. Some view the next stage as um, an opportunity for growth and new experiences. And I kind of put myself in that camp. Others see it this end, and I don't know who I'll be beyond that. And I don't want to have to deal with that. Um, I encourage you to start to think about some different things because, and again, I understand change can be hard, but you need to ask some other questions. You really do. Um, and here's sort of the mindset that I would encourage you to think about. Be defined by who you are and what you can yet do. Don't be defined by what's already occurred. It's another way that I just try to say, don't hang on to the past. Okay. There's wonderful things that can still come. So I again would encourage you to be very specific with this process. Um, Let me give you some example questions. What are you looking forward to in retirement? What concerns or fears do you have about retirement? Do you view this again as an end or a beginning? When thinking about retirement, what are your expectations? This is big. Are your expectations, excuse me, compatible and in line with the expectations of your significant other? If they're out of alignment, it's not going to work. You need to be moving in the same direction together. Once you stop practicing, what will you miss? Are there alternative ways to meet that need? It's not a coincidence that I have visited with 1,200 law firms over the years that I've done. I'm coming up now on 700 CLEs. Um, I enjoy being on stage and interacting with people. This has been a good fit for me. But why do you think I also look at something like Disney or cooking in a restaurant? I'm meeting the same kinds of needs, but in a slightly different way. So I just enjoy people. I like to make a difference. I really do. Um, do you know anyone in your mind who has successfully retired? This might be, again, a family member, a good friend, or even a fellow colleague. If so, have these discussions. What worked for them? How did they do it? If you don't know, um, you ask. Just figure this out. I've done a tremendous amount of learning, and it's really helped me move forward. And I know where I'm going. I'm now, in addition to when, and it's still a range, and it's not imminent, but I'm also now working on a transition plan. I want to make sure Alps captures my intellectual capital before it walks out the door, just as one thing. Um, what kinds of things do you enjoy doing in your spare time? From cooking as an example. What are your passions? Is there something you've always wanted to do? What are all the things you hope to accomplish in life that remain undone? My wife and I have a little bucket list of places we'd like to go and experience, and we will. Here's a tough one. How do you want to be remembered? And what can you yet do to make sure that happens? And it's tough because we really do need to dig deep and explore this. Okay. There's a difference between saying, gosh, I'd like to be remembered as just a good guy. Everybody just said, Mark was a good guy. I don't even know what that means. But how about I'd like to be remembered as making a difference? I've always been so committed to this or that charity and just making something up here. And I'd like to perhaps work on some type of fundraising campaign and really make sure this charity is firmly established for the long term. Okay, that's something different. Now there's some meat on that bone. Okay? Are there aspects of your professional personal life that were particularly satisfying? Think about things that you continue to be proud of. If so, is there a way to carry that forward into retirement or perhaps even build on them? So it's a process, hopes, fears, expectations of you and others close to you. Um, so a lot to think about. But I'm telling you, this is the key, a big piece of having a retirement be successful or not. Now, we can also talk about what will you do? And, now we're really starting to pin this down. And this is where I'm still very much up in the air. I have multiple tracks, quite literally, that I'm thinking about. But it doesn't mean that again, when we think about sunrise, sunset for a lot of people, this is the end. The train track doesn't go any further. It doesn't need to be that. Okay. Sometimes, perhaps again, a serious disability is not the end we expected, but it still doesn't have to be an end. There are things that you can do. A lot of lawyers want to find some way to still maintain a relationship with law because they really don't understand or know how to identify. They've been law is so much of their entire life. They don't know how to walk away from that completely. Well, you don't have to. You could become an expert. You could move into alternative dispute resolution or mediation. You could teach. You could do pro bono work. Boy, is there a demand for that. You could invest in the bar. You could be a mentor. And hear me clearly, folks. The need for mentors in the legal profession is huge, absolutely huge. You might even enter politics. You know, again, it's about trying to find a way to leverage your intellectual capital. Now, if it's not the law, is it time for a different career? You know, one of my favorite sort of Disney stories. There was a gentleman many, many years ago, and Disney wrote about this guy, which is how I learned about him. But he was in his early to mid 60s, and his wife unexpectedly passed away. And before they could really have the wonderful life that they had always dreamed about. And he was really quite devastated. Ended up, because he always wanted to go to Disney and loved Disney, and went down, applied for a job at Disney World. And there's a little story about how this all came into place, but he ended up being a greeter and just welcoming people into a very large, beautiful hotel that's part of the Disney property. If you know it, it's the Grand Floridian. And he had a 25-year career there. He's one of the most photographed employees ever at Disney. He watched families grow up, kids grow up and bring their own kids. They knew him, and he had a wonderful life. And it was a whole second career for him. Um, you know, is it time to give back? Church, community, the arts. Is it time to focus on yourself and or significant others? It is time to, just spoil the grandkids. To go to these places you have always dreamed about going. There's lots and lots of opportunities. So these are the kinds of things that I encourage you to think about. Now, with all of that out there, figured out, the day is eventually going to come where it's time to start this process of winding down or winding up, closing, however you want to describe it, the practice. So let's take a look at this. What are we talking about? Now, as we go through this, I do want to share, you know, I'm going to talk about this in the context of, for instance, if you're a solo and these are the things you are going to go into retirement, you're going to wind down, these are the kinds of these are steps you should be taking. And I will share, folks, there is a full checklist on both winding down a practice and winding down the business side in the materials. But this is also very, very similar. If you are ever asked, or the need comes, you're going to step in and act as a successor. It's pretty much the same. There's a lot of overlap here. The one thing we do have to acknowledge, there are going to be some variables in play. There's a difference between winding up a practice because someone's been appointed to the bench and winding up the practice because we're really just going to transition into a retirement. So there and sudden illness would be, these windows could change. But normally, understand this doesn't happen overnight. In a typical solo practice, we normally will talk about 12 to 18 months. Um, so just be aware of that. Um, okay, what do we need to go through? I think where it starts is we need to assess the status of all active matters and build out a timeline. Um, here's everything that I have open. Here's how long it's going to take to close, depending on the circumstances. You obviously want to finish everything that you can, and where we just know it's not going, you don't have the time or the ability to finish things, we need to start to see if we can find someone else to step in and pick that thing up. Just hand it off, and because we've got to everything needs to come to conclusion here, whether you can do it or not. We can't just leave things hanging. So um, I would notify staff, at least key staff, if you have staff, some do, some don't, but particularly key trusted staff, because you're going to need their assistance, and what they can do can be just make the transition so much more smooth. Um, Dealing with questions and just helping with some of the administrative type things that need to be done. I understand the risk that some fear. But I think being forthright and coupled with, when the time comes, I'll do everything I can to, write a great, uh, yeah, not resume, just senior moment, but recommendation. There we go. I have great recommendation here for you and do whatever I can to help you transition when that day comes. But, um, they are going to need time to transition too. And I just think in my mind, it's just the right thing to do. Um, obviously, as we close as many matters as we can, please stop taking on new matters. Okay. If if particularly something you can't complete, if you want to take on a few little things because you have the time and okay, that's fine. But don't take on anything that at the outset you can't complete. That can create some real problems. Um, I'm not going to get into all the stories here on this one, but I've actually seen some viable claims come out of that. Um, Notify your clients as we get close to this transition actually happening. You don't need to send that out 18 months ahead of time, but as the matters that you can't close, depending on what it is and when the handoff might occur or how this is going to occur, we need to send the letters out. If it's a more urgent situation, sudden illness, I call these attorney leaving the practice letters, and, due to, and you don't have to spill your guts. There's no ethical rule that says you have to come clean on all that's happening in your life. But due to some personal issues or the different ways to say this, I will be closing my practice within the next week, the next month. You give them the options. I can hand off files. You can pick them up. There's steps to go through here, but you do need to notify the clients, inform about the time limitations. So if it's similar to when we complete a matter, I'm not sorry, when we withdraw from a matter, which is really what we're doing. It's just a different reason for it. But whenever we are stepping out, we have an ethical obligation to make sure the client is completely informed of the current status of their matter and informed about things that still need to be done. A key and obvious one be sometime a statute. Nothing's been filed yet. Statute's running. You need to get another lawyer as soon as possible. If you don't, if this other lawyer, find a lawyer soon enough, or the lawyer doesn't file something on your behalf, you forever lose the right to try to recover from this claim. You need to allow clients to make informed decisions going forward. So what are the things that they need to be aware of, still need to do, and the ramifications to them if they don't follow through. So notify the court, submit motions to withdraw, file substitutions of counsel where necessary, double check to make sure these things get taken care of. Preserve client files. Obviously, we will talk about what that means here in a little more depth shortly. Notify clients of file storage arrangements. And one little comment on that one. Sometimes lawyers will want all their closed files because they just don't want to deal with it anymore. And I understand, I get that. And they want some other firm to hold, and they'll come to some agreement. Some other firm will agree to take this on. Please understand, you can't, absent client awareness and permission, just turn over all your files to somebody else. That's not preserving and maintaining client confidences. Think through that one. Close out your trust account. And folks, if it is not reconciled to the penny, I don't care how far away you are from thinking about retiring even, fix it now and don't let it get out of balance ever again. Stay on top of this. I am telling you, sometimes the successor attorney goes in and these financial records are in such shambles. I've seen situations where it's taken 1 to 2 years just to balance the books and figure out what the heck was going on. And if you don't think that costs something, I got to tell you, you're wrong. So make sure you close out your trust account responsibly. Everything needs to be balanced. Money needs to be returned that's not earned or passed on to the next successor counsel, depending on the circumstances. Sometimes there's money there that's been sitting for 5, 6, 7 years. You have no idea where the person is. And, what do you do with that? Well, it's once you do everything you can to try to turn the money, it's probably going to be subject to your state's disposition of unclaimed property act. So to go to the state. But, we have to wind all this down. It's not optional. Preserve your books and records. I'll talk about your files here momentarily, but when we talk about the books and records in terms of the financial side and all this, and a lot of states, it's 5 years if you look at Rule 1.15. But I encourage you again to check your local rules. Sometimes some of these numbers in terms of how long changed just a little bit, but just from a risk side, I think 5, 6 years on finances is probably good enough. General accounts, we're going to close those down too. But here's a question that comes up. Can we kind of close down the firm in terms of just the storefronts closed, no work client, but sort of keep it active a little bit to still collect money that might be coming in, and just operate the general account for a while until the everything's wound up totally. Well, of course you can. The closing doesn't mean you close on everything on June 5th. Okay. Anticipate future contact problems. There are different ways to deal with this. I can appreciate that you don't want to keep a number active anymore because the firm's not there, but you might see if the phone company will hand out an alternate number or give you an alternate number. So if this old phone number gets dialed, 6 months from now, there'll be a notice that, oh, here's the new number to call. There are different ways to handle that. Contact the bar, review your malpractice insurance policy, see what, and we'll talk about tails here shortly, that you're going to want to notify them. And then you just go through all the steps of winding up the business. It's everything you need to do to turn out the lights, turn the lease. Again, there's a whole checklist there, but that's the gist of what we need to talk about and take care of. So, okay, next up. Let's talk about some interesting things. Because the the transition piece is at times, how do I want to say this? It's not necessarily always I'm practicing law and I'm going to transition and fully retire. Sometimes there are other things that happen. And one of these things that I want to talk about is of counsel relationships. I'm not going to dig into this in terms of all the spins, but where I want to come at it from is, and I see a fair amount of this, a solo attorney may keep part of his or her practice open for a period of time, but as we start transition, he or she may go of counsel to another firm. Okay. And that sometimes is just testing the waters. Sometimes, we're seeing, do I want to buy the whole firm and bring everything in? There are different reasons for doing this, but I want to talk about this for just a little bit. When it comes to of counsel relationships, first off, don't play any games with this. Let's sort of talk about what is an of counsel. And an of counsel lawyer is really somebody that will have a close and continuing relationship with the firm he or she is of counsel to. Well, what does this close and continual relationship thing mean? And these are things that come out of a number of ethics opinions around the country. Really, it's defined as providing for close, and they use the same word, ongoing, regular, frequent contact for the purpose of consultation and advice. So, in other words, it's not any sales kind of thing and whatnot. You are actually advising firm clients that you are of counsel to. You are there for advice and consultation. Okay. Your intellectual capital as a lawyer is being put to use. That has one interesting little repercussion. So, and I'll make me. So if I have my solo practice and I'm going to do this temporary transition, maybe, I'll come off counsel for you. I'm going to wind down some things, keep my own practice going for a bit because I've done a lot of work and this money's coming to me. Yeah, that could be one reason, but I now work as a lawyer at two firms, my firm and the firm I am of counsel to. I need, if I want to have coverage for all the work that I am doing, to be on two policies. I am employed with, or I work for or with two law firms. Okay. And a lot of lawyers, and I only bring this up because a lot of lawyers assume and think I have a malpractice policy and that covers me for everything I do as a lawyer. That simply isn't true. There are lots of things that you can do as a lawyer that may or may not be covered under a malpractice policy. This is just an example of one of them. So, because the policies say we will cover you for work that you do in an attorney-client relationship that are professional services as defined under the policy and that are performed on behalf of a client of a named insured, which is a firm. So if I have an ALPS policy, my policy will cover me for everything I do in my solo practice. It's not going to do anything for me in the counsel situation. I need to be added to that firm's policy to be covered. Okay? So something to think about. Um, okay. Where do I want to go next? Give me just a moment. Okay. Let's talk about tail. I had an interesting call. Oh, I don't know, maybe 3 or 4 years ago from a lawyer. I have just heard about your company, and boy, you guys a great reputation, and I really, really wanted to come over. Here's the issue. I'm retiring next, I was in a couple of months, next May or something, and I would like to purchase my tail from you. May I do so? Who do I contact? And I had to say, I'm sorry. No. A tail is not a policy. We cannot sell you a tail. I mean, it's not a policy. You can't come buy it from us. Now, if you'd like a tail, you need to contact your current carrier. Okay. So that's the first thing you need to be aware of. A tail, and we talk about I have tail coverage or tail policies, and I get, but a tail really is better referred to as um, it's an endorsement, an extended reporting endorsement. Sometimes they call them ERPs, extended reporting period. It is an endorsement that gets added to the final policy that's in place that is providing coverage for you. Okay. All it does is extends the period of time that you may report a claim. So think about it this way. If you retire June 1st, there's no practice to insure going forward, right? But you still have the possibility of claims arising from work that you did up to this June 1st date. So you pay money to have the ability going forward to report claims that arise and would normally be covered under the provisions of that loss policy in play. Now, there are different periods. You can get 1 year, and this varies a little bit by carrier and policies, and all of this language in terms of what your options are would be set forth in the policy. But normally you have options like 1, 2, 3, and 5 years and unlimited. Some selection of those. Some companies may never offer unlimited, others, it just varies. Price ranges typically run from 100 125% for that first year, and will max out around 300% of final policy premium for the unlimited. Now, why do I bring that up? And this is for solos and firms. If you're going to look at tails, it's not something you can finance. It's you pay on the day that you select this, and it needs to be paid in full. So a final premium at a firm of 2 to 3 lawyers, and they're all retiring, was I'm just making something up here because premiums can be all over the map on locations and practice areas and experience, et cetera. But that's just say it's $15,000. And they did a lot of estate planning, so they want this unlimited tail. You need to have 45 grand in the bank to pull the trigger on that. Can you start to see where I'm going? Financial planning. We need to think through these things. Don't ever practice in retirement. Do the occasional will for, favorite niece or something, or the neighbor, whoever, just as an example. You're not covered. But lawyers will do this because, well, I have a tail policy. No, you don't. You have an endorsement that allows you to report claims from the work you did when you were in practice. But anything in retirement, good luck with that. So a tail offers no new coverage. Other mistakes that lawyers will make, I'm transitioning, I'm slowing down. The last couple of years, I'm going to boy, these premiums have been expensive, and I'm only working half time, quarter time now, and I don't need 2 million, 2 million. So I'm going to drop it down to 500,000, 500,000 to save a little green. Okay, I think God bless. When you go, though, and you get to the end and you say, I'd like to buy a tail now, but as I think I need this to last, the rest of my life, and I did a lot of estate work, and I only because a lot of people understand the risk is long on those types of practice areas. So I'd like to bump this up and have my tail policy be 2 million, 2 million. No, no one is going to sell you that. They can't. All they can do is offer an endorsement. So if the final policy is 500, 500, that's it. Think through. be careful about allowing it to decrease. This is unique to solos, this next statement. Sometimes solos, as they approach you a little shopping and may save a little premium dollars by jumping to a different carrier. That could end up costing you a lot of money. And here's why. Most companies, if you are solo and have been a solo for the previous 5, 6, 7 years, these numbers vary, but 5 is a good year. You'll see a lot of 5s out there. And so you've been consistently insured and you are fully retiring, totally walking away, you can get a free tail, unlimited. So again, think about that. That can save, I've just shared what these tails can cost. That can be a nice little perk. I don't want to see you losing it. And finally, don't put off purchasing a tail. Start when you are thinking about retiring. I would say if you haven't had a conversation and have some and some of this stuff will be set forth in your policy too, but you really want to start talking with your carrier 3 to 6 months out and start to talk through options and think about, how do you want to, what do you want to do? And so you know what your options are, to include when do you need to make the decision. Some carriers, if the policy is, you shut down, if the policy ends, May 31st, because June 1st, you're done. If you haven't purchased and elected a tail before it ends, you lose the right. Others may give you some periods of time. We're not talking, 2 years. It might be, a month, and it'll vary. So don't unnecessarily allow the opportunity to make this decision pass because you haven't checked with your carrier or looked at your policy and you had no idea what you want to do, because we're so tied up in closing things down. And this can come up particularly in these shorter transitions because we're so involved in dealing with the crisis or whatever it is that's making this transition short and fast. Don't wait. Don't miss that. Okay. Let's talk about files and closing files. The biggest question that comes up for me is how long do we need to keep these things? So that's maybe start there. You're going to hear, all kinds of thoughts on it. And some lawyers and firms say, I'm only keeping this stuff for a year, if that. Because if we don't have files, they're not going to sue us. And there's just so many excuses. No, I would encourage you to look at a 7-year range. The ABA's got an informal opinion a number of years ago that says 10. But I am, oddly enough, a little more aggressive on this one, perhaps. I like the 7-year range. And here's why. Why do we keep these things? Well, I shared that story at the very beginning. The files were destroyed and a claim came up. Well, if we don't have a file to defend you with, this is a problem. Okay. We keep them once we're done and fully retired, to still defend in a malpractice claim. What's the statute of limitations on malpractice? And do this under contract law. In a lot of jurisdictions, we're talking 5, 6 years, and we sort of add 1 year for good measure. And that's going to take care of most of the risk. So I like that 7-year range. Now, of course, there's going to be some exceptions, and I'll read through, files where the statute of limitation has not yet run. So that's, if you're looking at shorter periods or, I just statute might be dealing with, minors. That'd be another one. So files, again, involving a client was or still is a minor. The statute is going to still be ticking. State plans for clients who are still alive. The general rule on that is you can destroy 2 years after date of death. Files that contain agreements that have yet to be executed or not fully paid off, files that establish a tax basis on one or more client assets, adoption files I tend to keep, support or custody files with continuing support obligations, files with renewable judgments, corporate books and records of active clients, files of clients convicted of capital crimes, and I might think about keeping files of certain problem clients. So there are some exceptions there. One of the other things that I want to make sure that you do is, what do we need to keep in these files? Um, I would I want to make sure that you absolutely have I want to make sure you capture, if you will, all of the substantive information. Remember I earlier on talked about the advice being given, the decision-making process. Make sure that you have all the digital information, okay? Text, email, all the substance stuff. Now, this is partly thinking about closing files as well, but I want you to keep a complete file versus, we can throw out, at least call these things and get rid of a lot of stuff. No, I want a complete file preserved for this entire time. We also think about digital files because more and more the everything is getting digital and up in the cloud. And I like that. Okay. As a risk guy, I don't have any issues with that. But I do want to say the plan must include digital files. A lot of people, well, digital, it's so cheap and inexpensive in terms of storage space anymore. We'll just keep it forever. No, that's not how this is going to work. Um, the fact that a file is digital doesn't change anything for me. What changes is when the time comes to destroy it, the we need to destroy it in a slightly different way. Um, I please don't just take all this to the dump like the unsuspecting spouse does from time to time. I encourage you to incinerate, shred, commercial shredders, do whatever needs to be done. But you need to do, digital shredding as well. And also think, where is all of this digital data? So as you're closing your firm and winding down the business side of this too, you can't donate or just send to a recycle center computers that have all this client data on it. You need to properly destroy this stuff with a digital erase, or physically have drives shredded. That's true for phones, backup tapes. We need to think about all the places this data is. This is not optional, folks. The obligation to preserve and maintain client confidences, 1.6. There's not an exception for those that are retiring and just want to get rid of all their tech. There's no exception for that. Okay. The rules are in play. So, okay. What's next? We're just about done here. I do want to talk just a little bit about firms. You know, I have seen all kinds of problems as a risk guy. I want to make sure intellectual capital doesn't walk out the door. And I've seen this happen a number of times. Have a plan if a senior attorney because sometimes in smaller firms, we may have a lot of if you will, firm and name only kinds of things going on. I have my clients, you have yours, et cetera. And there's not anything inherently wrong with that. It's a whole nother discussion on some risk with that. But if this attorney has a lot of intellectual capital that could be useful to the firm, and we do want to see the firm continue on, how are we going to capture it? Have a plan. Um, in transitions, maybe the attorney doesn't necessarily want to go out turning the lights off and just walk out one day. We want to slow down. It could be some physical or mental health issues in play or something. But, mentoring is a wonderful opportunity and also another way to capture intellectual capital. And think about client transitions. I have seen firms not survive the departure of a senior partner or survive the unexpected death of a senior partner. There's all kinds of things that can happen here. When there's no transition plan on a departure of an attorney, of a firm attorney, clients see this as an opportunity to jump. Why would you not introduce us? What's wrong with the rest of these folks? I mean, you allow all kinds of just worries to come into play, I would have a plan how to transition clients, make some introductions, be part of the transition. You also need to keep your files at current too. Let me tell you one story. It was a firm that had mostly gone into the cloud and think Clio type stuff, and it was very effective. But one of the older lawyers had he's just not the most tech savvy kind of guy, and he transitioned and tried and got a lot of his stuff in there, and he unexpectedly passed. And the firm felt very comfortable that they had everything because we're all digitized now. We could just assign a new lawyer, etc. One of the partners said, uh, I just think we should go in and go through his files and see what's on his desk and all this, and just to make sure. Turned out five major matters were never entered. Now, he fortunately was very good about keeping his files current, papers, everything, the decision-making process, it was all good. And so they could pick this stuff up and run, and no claims ever came out of it. But what would have happened if that one attorney just didn't say, we should go look, okay? So don't run with some assumptions and make sure that your files are current, that we know where everything is, et cetera, et cetera. The final thing I think, if we don't do a lot of this stuff, clients can and will walk out the door. I don't want to see you lose revenue, particularly if the person is a key rainmaker. I have seen fails firm because firms fail. Sorry about that. As a result of not doing these kinds of things, and once the key client goes out the door, it's not good. The one final thing that I'll share before we wrap up, sometimes this question comes up, can you sell your practice? Yeah, you can. I've seen, and I wouldn't say this is extraordinarily common and happening day after day after day. That's not my experience anyway in the risk world, but you can. I just want to remind you of Rule 1.17. You are to sell the entire practice or an entire area of practice. You can't cherry pick or have someone wanting to buy cherry pick. It's all or nothing, okay, of an entire practice area. You can have and restrictions on this. One of the most common, and it's in the rules that there can be geographic or jurisdictional restrictions, and you need to. So if I sell the estate planning side of my practice, but I still want to keep the bankruptcy side, I can't sell the practice, the estate side, and then move across town and set up a new firm in estate planning and compete against you. I'm out and I have to stay out. Okay. You really need to find a competent buyer. Just because somebody comes in and wants to buy, you know, you need to make sure, because you're selling access to your clients. Now, they may or may not go, and they have that choice, but you have to make sure that it's a competent person that you're selling things to. Client notification and consent is obviously required, and you can have some default statements in these notices. Here are the options. If we don't hear from you within 90 days, we presume that it's fine to transition and sell your file, or have it go with this new firm that's buying everything. A really important one, particularly for the purchaser, you cannot finance the purchase by increasing fees on any of the matters that you're purchasing. You are bound ethically to honor the original agreement. Now, where that could potentially change is after picking this up, you have to abide by the agreement. But if there's some change, additional work or change in scope, well, that changes things a little bit. But you can only, you still have to honor the fee agreement for whatever the basic stuff was, the additions and the change, you can play with that a little bit. But so that's the down and the dirty. I see we are pretty much here against the half hour. Or I'm sorry, it's been the 90 minutes. Um, Happy to answer some questions. I do want to share very quickly, and then maybe we'll see if we have any questions. Um, I am not a traditional risk manager. I just want to underscore that. I am not a CRO of a corporation. I am basically hired by ALPS to be a risk manager of the bar at large. You do not need to be an ALPS insured. There is no fee to visit with me. If there's something that I can do to help any of you, if ethics, cybersecurity, risk management, malpractice avoidance, the list goes on. Here's some contact information. I'm your risk manager too, and I'm happy to try to help. So, Nina, I will turn it back to you.
Awesome. Thank you so much, Mark, for all of your insights on succession planning and its importance. Now we can go ahead and move on to those questions. Looks like we've got a few in the chat.
Okay.
First one is, if your spouse is an attorney and is your power of attorney and trustee, but doesn't work in your office, can you add the spouse as a signatory on your operating account on your IOLTA?
Oh, that's an interesting. So I want to make sure. Attorney spouse, different firm.
Correct.
I would say day to day, no. I want to underscore that I can't speak for your bar. Okay, these questions you always want to run by bar counsel or ethics counsel in your jurisdiction because this is just Mark's opinion. But here's why I say no. You are providing access to client funds and client information to a non-firm attorney, and you don't have any permission by clients to do that. Now, what I might work if your spouse was named as successor, and perhaps you could have a contingency authorization for signature authority. So upon my death, my spouse has the ability, and that might work. But I would be cautious about that. I don't like the fact that we have somebody outside the firm with that authority.
Understood. Thanks for that insight. Our next question is about tail coverage. This
Okay.
person says, I am a 5-lawyer firm with the policy being issued to the firm. I have been of counsel as an independent contractor and am covered by the firm's policy. When I retire soon, does the firm's owner ask the carrier to purchase a tail policy for me, or is one even needed as the firm will continue to be in business after I leave and the policy will still be in place?
If the policy Well, okay. So yes, the policy will still be in place after you leave, assuming that the firm is a very stable firm and likely to continue on post your retirement for at least 3 to 5 years. You have no worries about that. I'm not going to worry about a tail. All these policies have former attorney language in them, and you can really rely on that. Sometimes a departing lawyer um, doesn't necessarily want to not be in some control of that type of risk. And they think, well, could I get a tail? The firm may or may not pay that for you. And the insurance company may or may not make one available, but it's certainly an option. And, again, it gets back to saying 3 to 6 months out, check with your carrier and see what the options are. Some may have tails available and others not. And if not, former attorney language is what you're going to have to rely on.
Awesome. Thank you, Mark. Our next question is, how long do I keep the tail specifically for patent attorneys?
Oh boy. Um, this, I am one. Okay. You're talking to a lawyer, risk manager who works for an insurance company. I get back to this risk taking thing. I'm not a high risk guy. Um, in my mind, when I think about how long a statute of limitations on malpractice could be running on various matters, I get back to that. Okay, I'm thinking 5, 6, 7 years, unlimited. The max yearly that I've ever seen is 5 years, so that's going to kick us into the unlimited. I'm one. If unlimited is affordable, why the heck not? It's if it's in your price range, and it's going to allow you to sleep at night. and just not worry about it, as opposed to, well, went with 3 years because, uh, you know, it's, of course, the odds of a claim drop over time. I mean, it's just the way it naturally, but I can share, this is not in the IP space, but I can share, we have seen claims arise on work done 10, 20, and even 30 years old. So it does happen.
Awesome. Thank you, Mark. Time for one more question. So this person asks, what would you say are the pros and cons of a phased retirement approach? And are there any specific ethical concerns with that approach?
Well, by phased approach, I assume you mean with your firm, whether it's a solo and I just start to slow down, or I'm transitioning up counsel with my firm or mentor, whatever that means. I have zero issues with a phased approach. The ethical concerns that could arise would be, again, we sort of talked about a common one where I'm slowing down in my own practice, but I'm going off counsel with another firm. We need to, conflicts come into play, confidentiality comes into play because you're working at two firms. So those would be some of the ethical issues that come up. But I'm not aware of any ethics opinion that says, you know, transitioning slowly, this phased approach is going to be an issue. The one other exception I could think of, and this really varies by jurisdiction, sometimes a phased approach is I'm going to sell my practice, 100% of my practice, but stay involved with the firm to sort of drop my intellectual capital and to help manage the transition, et cetera. That can start to get in some ethical muddy waters. If you're thinking about phasing out in that way, I would encourage you to visit with bar counsel or ethics counsel in your jurisdiction to see what the response is on that one.
Awesome. Well, thank you so much, Mark, for taking the time to answer
Welcome.
these questions and your wonderful presentation. And thank you all so much for joining and asking your questions. We want to thank you all for joining us for another Justia webinar. As I mentioned at the top of the presentation, I wanted to remind you all of the services available to you through our website platform, Justia Elevate. It is our innovative, feature-packed website solution designed specifically for law firms. It's built on a powerful WordPress-based platform and offers tools like our Justia AI Writer to help you write content for your website, as well as our AI-powered Justia Chat to help you connect with more leads for your firm. Plans start at just $82.50 a month when paid annually. And if you'd like to check out the information or the pricing for your firm, you can go to elevate.justia.com/price or give us a call at 888-587-8421. And have a wonderful rest of your day. Thanks for joining. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.